Thank you. We've had our three primary witnesses. I'm going to give everybody some latitude because I know it's an emotional issue, but I want to make sure we have time for everybody and we have a number of items yet ahead. So if you could be brief, please. Thank you.
I will, and I have a handout. If you could help me, Tony.
Give that to the sergeants and they'll get it to us. Thank you.
I'm sorry, what did you say?
Oh, the sergeants will get it to us.
Oh,
yeah.
Thank you. Thank you for this opportunity to speak. I'm Holly-Ann DeLille. I'm a lifetime member of Californians with Disability Rights, and I sit on the board of Designing Accessible Communities. And I want to ask you, what is the real purpose of this bill? I don't believe it's money. We know that less than a half of 1% of the lawsuits in California are about accessibility. So it's not a huge monetary impact on the state or on the businesses. There's also the $15,000 tax credit per year. And I understand that it's in response to a couple of attorneys in California who write businesses and say, okay, you've got barriers, send me $2,000 and we'll settle this out of court. Well, if you get $15,000 for a tax credit to remove barriers, you could just say, okay, I've only got $13,000 this year. So, and $2,000, I know it's not what I want, of course, as a person with disabilities. I want really good injunctive relief. I want those barriers removed, and I want a court settlement overseen by the judge that spells out in exact how many inches they're going to achieve that barrier removal. But even if they go that way, where they don't talk about injunctive relief, they just try to get their $2,000, 25 cases a day, or whatever it is they're doing, $2,000 is an inexpensive notice that you're vulnerable to a lawsuit that could cost you thousands. So I don't think this is about money. And I don't think it's about ignorance. The ADA's a quarter century old. There's a plethora of material out there, online and everywhere, is to find out what you need to do to remove your barriers. There's California laws requiring that businesses be accessible when they're built, or when modeled, were passed in 69 and 72 in the Health and Safety Code. That's more than 4 decades ago. So, and there's a ton of information available now that the ADA is involved also, and our building code reflects the requirements in the ADA, so you comply with California Building Code, you comply with the ADA. It's not ignorance. It's not ignorance, it's not money, and it's not ignorance. And I've just handed you a piece of paper that has my arguments on it, plus a photograph of me with all the letters that I've written since 1993. And less than 5% of them are responded to. And in the letters, I tell the business, look, I experienced this barrier. Here's information where you can go to get more information. I'll be happy to recommend a code expert to you. And here's information. I give them the exact form number for the IRS form that they can use for their $15,000 tax credit for barrier removal. Less than 5% of my letters are responded to. And this stack in the photograph doesn't reflect the 50 or more that I have, the businesses that I've written via email. As Tony said, the horse doesn't want to drink. There's no monetary, there's no ignorance. They've received really polite letters from me, and they don't respond. The horse doesn't want to drink. So it's not about ignorance, it's not about money, it's about willful disregard. And so why is that? Why do you want to create and codify into law that when people are discriminated against, they are not to receive any compensatory damages, monetary damages, because if you gave us monetary damages when we're discriminated against, you would be saying we have value. And there seems to be a real need to say, even to codify into law, to destroy our civil rights and say, by law, we have no value. And why is that? Because I think there's fear when you look at us. We are a reminder of your own humanity, your own vulnerability, your fragility. You know, we're broken, we're damaged, we're repulsive, and you don't want to associate with that. You don't want to think that you're really like us and we're really like you. You don't want to go there. We remind you of your mortality, so you have to come up with this bill that actually codifies that we are not like you. Please don't do this to us, because if you do this to us, you're doing it to yourselves. You can join us in a heartbeat. We're all still human. We all have value. I want to thank you for your time. And I just want to say, I know that Terry is going to speak next. She doesn't have a computer that's working, so I asked the assembly yesterday via email while I had her on the phone. She has an amplified phone. I asked her if she would, I asked the assembly staff to make sure that she can participate today because she has a hearing impairment. She told this committee last week that she couldn't understand what was going on because she has a hearing impairment. And so you knew last week and you knew as of yesterday that you needed to provide this reasonable accommodation via real-time captioning for this citizen who's here to protect her rights, and it's not here. Maybe it's because maybe some of you have a hidden disability and you do everything you're empowered to make sure it stays hidden because you don't want to be identified with us. Maybe you have a hearing impairment or a hearing aid or a bad hip or something, but please don't pass this law, and please provide this accommodation.
Thank you. Next witness.
My name is Terry, and I'm sorry I'm in this awkward position that I can't see the members of the committee. I've been at this now for 40 years trying to get access, and I'm not representing a committee or an organization, but I am to memorialize the thousands and thousands of people who filled the halls of this building, who filled the city halls up and down California for years to demonstrate that we needed rights. In 1973, the Federal Rehabilitation Act of 1973 was passed. At that time, Joseph Califano was the Director of Health, Education, and Welfare. The bill that passed federally said that we had a right to transportation, a right to housing, a right to jobs, a right to education. In other words, we had all the civil rights of every person in the country. The first thing that he wanted to do was to cut the teeth out of that bill, which was the enforcement. A whole lot of us ended up demonstrating. Now, we'd learned a lot of things at the sit-ins and the demonstrations that we had gone to help our brothers and sisters who were afflicted with the Jim Crow laws and segregation and prejudice. We learned a lot, and they came to help us for our rights. This bill apparently is trying to protect businesses from mothers with handicapped children who have to push them. It's to protect businesses from gentlemen and ladies who unfortunately encountered an IED in the Forever War in Afghanistan and Iraq and other wonderful places in the Middle East. This bill is trying to protect everybody but the handicapped. I must remind you the reason for the law. The law is access not just to the physical building for its goods and services, but to employment. And by eliminating this vast group of businesses, you also eliminate any possibility that we'll ever get in there and get a job. I was here last week, and I mentioned then, I will mention it again. If you deny us access for all the other reasons, one, that we don't count as people, and two, because you don't want to fix the building. Oh, and by the way, the Chamber of Commerce, and I have gone to their meetings and I have talked to people there, and they have told me, we tell businesses, don't become accessible. Wait until they sue you, and then defend yourself and complain about it. This is just so incredibly wrong. It's cruel, it's vicious, it's evil. And to say we have to wait another generation for people to wake up and say, all human beings can become disabled because of our president's law. Previously, if you had a disability, you couldn't get insurance because of previous conditions. That has been overcome. And there will be a flood of human beings who have been denied not just access, but life. There will be a flood of people who will be able to get into the place that they can't get into. And this is going to say, oh, I'm sorry, just because now you have a right to medical care and you can get something fixed that you had wrong with you, we still won't let you in the building. As I said, we filled the building with people who were blind, who were deaf, who had cerebral palsy, who had what they used to call a mental retardation. We filled the halls with people who had every disability you can imagine and a whole bunch you can't imagine. And they did manage to get through to some people to say, yes, we have rights. I had a job years ago, and I rolled around the classroom in a little chair. And then they found out that I couldn't walk very well and fired me. And I had no rights until the Rehabilitation Act said I had rights. And at that point, they couldn't fire me because I was disabled. Too late. I was already fired. I don't see the halls of this building full of people with disabilities. I know some of you may have hidden disabilities, I don't know, but I don't see a lot of wheelchairs. I don't see a lot of people with canes. I don't see a lot of people with white canes. I don't see a lot of disabled people who are representing me. And so it's up to the able-bodied, the temporarily able-bodied, and I say that because most of you will not manage to live out your entire lifetime without a disability. There's nothing wrong with being disabled. What's being wrong is not having your rights accepted. This bill is so bad I cannot begin to describe it. Most businesses in America are classified as small businesses. And this says, okay, you not only didn't have any rights before, now you have none. I'm terribly sorry that I'm doing this, because after all these years, I didn't think we could possibly go backwards, but we are. I'm 81 years old, and I spent 40 years in and out of this building. I helped to draw up the plans to remodel when this building was, the other building was a shell, and I helped get doors that opened, ramps, accessible bathrooms, telephones, and all those things that we couldn't use before. If you don't have a disability, if you have no friends and relatives who have disabilities, if you have no lovers who have disabilities, you may not have a clue. But we're here to try to tell you to get a clue, because you may join us tomorrow. Thank you.
Thank you. Next witness, please.
Jeff Tom, representing the California Council of the Blind. I'll be very brief. The California Council of the Blind is the largest organization of Californians with vision loss. We broke with the disability community and supported SB 1186 for two reasons: to curb the abuses of a few bad actors, and because of the professed good faith of the business community to promote disability access. We've been rewarded with only bad faith. The business community has become the wolf in sheep's clothing, notwithstanding the good offices of the author. As we all know, if you give someone enough bites at the apple, they will gobble the whole thing. If you pass this bill today, we will be back in a couple more years, and even more of that apple will be bitten, and the rights of the persons with disabilities will be further eviscerated. Thank you very much.
Thank you.
Thank
Please.
you, Chairman Stone and members of the committee. My name is Connie Arnold, and I'm from Elk Grove, California. I'm here as a person with a disability, and I agree with all of the passionate statements already made by the people at the table and the last speaker, Jeff Tom. I feel like this bill is taking us back decades. I've grown up with a disability since age 6. I remember going to the park to play in a playground, being taken there by Crippled Children's Society in a van with no tie-downs, only to get an area of a sand pit and roll around and feel bad because I couldn't play with the other kids. I could not even reach the counter to buy an ice cream. This is wrong, and I'm telling you, kids today still experience the same thing. They experience driveways that are curb ramps. That's their curb ramp, a driveway in a residential neighborhood. They experience lack of access, and so many venues, it's ridiculous, from Disneyland to everything. I mean, I recently went back to Disneyland, and I said, wow, there must have been a lawsuit back in Florida, and they finally made some of the rides accessible, and I could go in my wheelchair. I always said river rafting was much more fun than Disneyland, because when you grow up and people can't carry you, you're denied access. This bill takes us back and allows businesses with 100 or less employees, which is really bigger than mom and pops, businesses to discriminate against us and get immunity for minimum damages after the discrimination and the denial of access has occurred, including the fact that a plaintiff's attorney who's filed a complaint and they've worked hard to bring up these issues, then if the entity hires a certified access specialist and gets a report and undertakes the barrier removal, like Terry said, after they get notice of the complaint, then they get 4 more months to remove those barriers. So the other issues, let's talk about the CAS program. There's no transparency of the reports that exist, and even building officials are certified CAS professionals who have, in their association, said at the end of the day, accessibility falls off the table in the level of importance. And there's no quality control in the area of knowledge of the disabled access specialist. So businesses are going to get CAS reports, and they already do today, in order to get some exemption of liability, whether it's for damages or some kind of thing. They get a few more days. But you've been told there's no interest really in actual compliance, because just a few years ago, the Independent Living Resource Center offered trainings to businesses, published flyers, posted it everywhere, and only one business showed up at that offer of free educational trainings. So it's really about banking money in their pockets by not putting in access, which also includes in this bill that it says technical violations, which of course right now is this, but then what else is going to get added later, that a claim based on a number of specified violations such as lack of exterior signs, the order in which parking signs are placed or the exact location or wording of parking signs, the color of parking signs, the color of parking lot, striping, faded, chipped, damaged, or deteriorated paint in otherwise fully compliant parking spaces, which is kind of funny. They're otherwise compliant. So you can have deteriorated paint where you can't even see the access aisle, which I've experienced, so you can't even park in the designated accessible parking spaces because you can't see where the lines are to park in and where you can unload your lift. And now they get an exception for that. You can have no signage posted and not see a flight of stairs, and your friend takes the flight of stairs in his wheelchair, and now after you experience the discrimination and the damages, you can't get damages. Okay? And the same thing with detectable warning surfaces such as truncated domes on ramps, except of course unless they're part of a pedestrian path of travel that intersects a vehicular lane or other hazardous areas. But there are so many areas that this would say, no attorney, you have a legitimate complaint, you've experienced a barrier. Now, no legitimate attorney. We're not talking the attorneys that the couple that have filed 50% of the cases, but we're talking about those attorneys that want to handle a case because they know you've been legitimately discriminated against, but they won't file it because of the fact there's exceptions here, and there's going to be too few people interested in enforcing these laws, and we're going to lose attorneys out there who are willing to enforce any of these laws. And let me tell you what I was told by an Asian businessman when I was talking about an accessibility issue. He said, let me tell you, if you were from my country, what we would do to you if you had a complaint about access. We would come to your house in the middle of the night, and we would get you, and we would tie a rope around your body with a rock, and we would take you down to the river, and we wouldn't hear any more complaints from you. And now what does that sound like in our past history? If anyone has a complaint about unequal treatment, separate but equal, segregation, our history in the United States, and I'm sorry for going on and on, but I'll try to finish up. A lot of these issues have caused damages and injuries to persons with disabilities, and this law makes it feel like, I already am not happy that I'm a person with a disability. I don't like having a disability. I don't like the ongoing discrimination I face, not just in California or the nation, but the world in trying to function every day to find an accessible toilet. It's like banging your head against a wall, finding an accessible parking space. It's so frustrating. It just builds up, and this law actually says it's okay. Your businesses are allowed to discriminate against you, and they don't have any liability, and there's nothing you're going to be able to do to enforce your laws of access. And then next year or 2 years down the road, we'll be back here, and they'll add a few more things here for exceptions. And then pretty soon, there won't be any plaintiffs, which is the ultimate goal, and there won't be any attorneys to handle any cases. And so there'll be absolutely no enforcement of disabled access laws, all while you roll back our rights under this bill. And I ask you, like all the other people have asked you, I am not a subhuman being. I am a person with a disability who has value. I ask you, do not pass this law, this bill. Thank you.
Thank you.
Mr. Chair, members of the committee, for the record, my name is Peter Mendoza, and I'm also a member of CDR, and I'm also a person with a disability who, as I mentioned previously at the last testimony, has a full life. What you're deciding today is whether people with disabilities are as equal as everyone else in society who's a protected class, and whether we have the same rights as those people and deserve to have our rights upheld. After I testified at this hearing, I got stuck in the restroom right down the hall. It's got the sign that says it's accessible. The door was too heavy and there wasn't enough strike site clearance for me to open the door. No one came in for a while and I was stuck for several minutes. I finally decided to call the CHP. I tried the various numbers that are listed for the CHP in Sacramento on Google. Do you realize there are 6 CHP offices that cover Sacramento? Nobody knew how to call anybody to help me out of the restroom. I happen to let you know that the Capital Protection Division is not listed in Google. Eventually, I got out of the bathroom. I spoke to Officer Dillon with the CHP, and she told me who to call for next time, and I appreciate her assistance. The issue is that we experience barriers every day. Most of the time, we do not litigate. Sometimes we do. We often try to educate building inspectors and businesses to make their business accessible. I would submit that there are, throughout the criminal justice system, there are a lot of good people and a lot of people that use the criminal justice system for their own personal gain, not just in disability access, but in all parts of our legal system. And there's only a small percentage of disability rights lawsuits in California anyway. We are not addressing the issue of building officials who do not enforce our rights, of other entities who do not enforce our rights. We need to show some courage today and not pass this bill and put together legislation that gives more teeth to allow building inspectors to enforce our rights, to allow the other public entities to enforce our rights when it comes to making businesses accessible. I'm not saying that all building officials are bad. A lot of them are good, but it's not a highest priority. When you raised your hand and took your oath as a legislature, you swore to uphold our rights. I'm asking you to do that today and vote no on this bill. Yes, there's work that needs to be done, but this is not the way. Thank you.
Thank you.
I'm Mark Basquez from Sacramento, and I oppose the bill.
Henry Contreras with the California Foundation for Independent Living Centers. We oppose the bill.
Thank you.
Mr. Chair and members, Kevin Baker for the American Civil Liberties Union of California, also in opposition. Just wanted to note real briefly that Senator Roth asked for 5 things from the committee last week. He prevailed on all of them. I hope it will be noted because unfortunately I find myself, after many years around this issue, sharing the concern of Mr. Tom from the Council for the Blind that unfortunately it appears some people are not going to be happy as long as businesses are being sued for not complying with civil rights laws. Thank you.
Thank you. Anyone else in opposition? Seeing none, I'll bring it back to the committee. Mr. Wagner.
I heard a number of insinuations as to the motives of Senator Roth or members of this committee and what we're trying to hide or something along those lines. And I'm going to let him. I'm going to let him go. We're all addressing the bill on the merits. There was, however, one specific charge that was made, and I'd like, if we still have somebody from the chamber here, to come up and say yes or no, this did happen or didn't happen. that the chamber is advising businesses just wait until you get sued and then deal with the problem. That allegation was made very specifically. It is very disheartening if true, but is not my experience with the chamber. Ms. Barrera.
Mr. Chair.
If I may.
Please.
Thank you, Assemblymember Wagner. The California Chamber of Commerce has never advised any business to violate the law. The Chamber of Commerce has never advised any business to just sit back and wait and not become compliant with access standards. The California Chamber of Commerce has put out numerous publications, has done numerous training seminars to educate their businesses on what the law is, how to become compliant, and what they need to do to become compliant to avoid any lawsuits or any problems with regards to construction-related accessibility standards. Thank you.
Thank you. Thank you, Mr. Chairman.
Any other comments, questions? Senator Roth?
Mr. Chair.
I'm sorry, Mr. Chu.
I first just want to thank all the stakeholders who've been involved in what I know has been a very challenging conversation, and certainly to the members of the disabilities community who's here. I think every one of us has heard what you have brought to us, and I know for myself, I think many of us want to figure out how we can ensure and incent that monies by small businesses are spent on accessibility improvements rather than going into the pockets of a handful of attorneys who unfortunately have really clouded this entire issue. This is an issue that I worked on for a number of years locally in San Francisco, and we work with the disabilities community and senior advocates along with small business advocates to move forward a number of reforms to address this area. But we all know that state law has really held us back. And I want to thank the author as well as our chair for a lot of work that they've done in the last couple of weeks to move us forward in agreement with many key stakeholders. I do understand that last week I think we came very, very close to a total agreement. We're not there yet. But from my perspective, I feel that the changes that have been made make sense. I also happen to think that specifically around the definition of small businesses, I have many small businesses in my district, and we know around the state where this threshold of 100 employees is really, it does constitute a small business, and those needs do also need to be addressed. But from my perspective, I think this legislation is very narrowly and carefully tailored to really incent employers and small businesses that are getting a CASP inspection to move forward, really providing them with an incentive to do the right thing so that they can put the right repairs in, and for a variety of reasons, including the fact that there's been a lot of work on this and we have to address this issue. I will be supporting moving this forward, and we'll make a motion to move it out of this committee.
There's a motion and a second. That motion is due pass to Rev and Tax. And I also will note it's not necessarily related, but this committee did put forward a bill, AB 1421, that's now over in the Senate, talking with Senator Roth and Senator Jackson, because it's in her committee over there. I know a number of members of this committee have asked to come off that bill. That bill is intended to go straight to the issue of the frequent filers, if you will, and get at the issue that is constantly raised about the small number of lawyers who are going after small businesses really as a business model for them rather than as an attempt to try and get businesses compliant. That clearly remains an issue. That's a bill that is working on that. We have worked, these amendments today are different than the ones that were before the committee last week, and as a result of a lot of discussions over the last week to try and get to agreement between Senator Roth and myself, and something that will be acceptable to this committee. So that is before us. Senator Roth, you may close.
Thank you, Mr. Chair. I just want to, as you know, since at least the mid-60s, if not before, the civil rights laws have prohibited both intentional and unintentional discrimination, pattern and practice, both of which, of course, are wrong. There is nothing in this bill that protects a business that intentionally discriminates against anyone, including a member of the disabled committee. There is nothing in this bill that prohibits a plaintiff from claiming and pursuing a claim for actual injuries. And there's nothing in this bill that precludes a plaintiff or a claimant from pursuing injunctive relief with respect to disability access issues. There's a little bit of a misconception, I think, perhaps among the disabled rights community, that this bill allows a business that has been sued or has received some notice, then some period of time, 120 days, to fix the problem. It's a very limited bill, and it requires that business, as you know, to have secured a CASP inspector and secured an inspection before any notice, before any claim, before any lawsuit, in order to qualify for that short period of time, relatively short period of time, to fix the problem. One of the speakers noted that we have a problem in the state of California with respect to disability access, and that speaker was absolutely correct. We have a problem. We all have an obligation to work this. We're trying to do it. I know my friends on both sides of the podium here will work with me, with the business community and the members of this legislature, to fix disability access issues and to make our public accommodations acceptable to all. And with that, Mr. Chair, I respectfully ask for an aye vote.
Thank you. Call the roll, please.
Stone?
Aye.
Stone, aye. Wagner?
Aye.
Wagner, aye. Alejo? Alejo, aye. Chow? Chow, aye. Chu? Chu, aye. Gallagher? Gallagher, aye. Garcia? Garcia, aye. Weber? Weber, aye. Mainshine? Mainshine, aye. Thurmond? Thurmond, aye.
That bill is out.